We continue our coverage of this week's question time in Parliament, and we go to a question from the Leader of the Opposition, Ms. Lindiwe Mazibuko, to the Minister of Justice and Constitutional Development. She asked whether he intended taking any steps in accordance with the President's comments that the powers of the Constitutional Court be reviewed. She said if that was indeed the case, the question was what powers will then be reviewed. In his reply, the Minister, Jeff Radebe, said his discussion document released earlier this week dealt extensively with the matter. The SONA statement by the President was consistent with the ongoing debate about the Constitutional Court as the apex court with general jurisdiction. He pointed out that the Portfolio Committee on Justice and Constitutional Development was currently considering the Constitution's 17th Amendment Bill and the Superior Courts Bill. These bills also look at the powers of the Constitutional Court.
Let me reiterate that the approach adopted by Cabinet with regard to the assessment of the impact of the decisions of the Constitutional Court on society, which has been linked to the President's statement, is not an isolated matter, but form part of a package of recommendations which relate to the transformation of the judicial system and the role of the judiciary in advancing the ideals of the Constitution. Let me once again reaffirm our commitment as the ANC-led government to the Constitution as the embodiment of the values of the African National Congress that it stood for and fought for. The ANC-led government will defend these values, including the independence of the judiciary and the rule of law.
Opposition leader Lindiwe Mazibuko said the purpose of the review was not quite clear. She said as far as the President's statement was concerned, it seemed to her that there were conflicting views on what should be reviewed, the jurisdiction or the powers of the court.
The Minister of Justice yesterday pledged to uphold the independence of the judiciary and the Constitution. However, his statement does not support this commitment, and it remains unclear what the ultimate purpose of this review process will be. In responding to the outcry over the President's comments, the President's spokesperson, Mak Maharaj, said that we should view the President's comments on changing the powers of the court in the context of this assessment. The President's remarks were clearly different to what the Minister is referring to here, which is the question of jurisdiction. He was talking about the powers of the court. The report that was released by the Minister yesterday has failed to clarify the very purpose of this review, and it hasn't allayed fears that the review will precede an amendment to the powers of the Constitutional Court. Will the Honourable Minister provide this House with the assurance that the Cabinet will not propose changes to the powers of the Constitutional Court, regardless of what the outcome of this review process is?
The document that we released yesterday is not a document about reviewing the powers of the Constitutional Court. It is a discussion document on the transformation of the judicial system and the role of the judiciary in the transformation project. So if the Honourable Member can have time to read this document, not to be influenced by party politics of the Democratic Alliance. The statement by the President was clarified even by his office not to be misrepresented by what the DA wants to read to what the President has said. The DA itself in the Portfolio Committee of Justice and Constitutional Development have views about the issue of the apex court in the Constitutional Court. So it's nothing unusual that the President has said. Everybody expresses opinions on what has to happen. If you care to read the Constitution's 17th Amendment and the Superior Courts Bill, you will realize that the comment that we're trying to suggest is ill-founded.
Ms. Mazibuko's colleague from the DA, Ms. Deborah Shaffer, wondered if the minister was not bridging the United Nations principles on the independence of the judiciary, particularly the principle of no unwarranted interference and no revision of judicial decisions except through judicial review.
Minister, in your own discussion document released yesterday, you quote from the United Nations Basic Principles on the Independence of the Judiciary and cite one of a number of key elements that are critical to the independence of the judiciary, namely prohibition against inappropriate and unwarranted interference with the judicial process and no revision of judicial decisions except through judicial review. Does the Minister agree that his so-called assessment is potentially such a revision of the decisions of the Constitutional Court, contrary to this United Nations principle, and which poses a danger to the independence of the judiciary, and if not, why not?
I don't agree with your assertion. There's nothing in the document that suggests that we want to encroach on the independence of the judiciary. The track record of the ANC government since 1994 affirms the fact that we are the ones that respect more than other people in this House the independence of the judiciary. As we speak, President Zuma is the first president of the Republic to sign a proclamation to create the office of the Chief Justice as a step towards reaffirming the institutional independence of the judiciary. If we were inclined to encroach on this independence, why we do go about such fundamental transformation of the judiciary in South Africa? So that's why I'm saying that read the document, not be influenced by party politics to gain cheap votes from the electorate.
The chairperson of the Justice and Constitutional Development Portfolio Committee, Mr. Lindiwe Mazibuko, referred to a statement by a well-known academic that the review could be a healthy debate by all stakeholders on the transformation of the judiciary.
When you, Minister, invite us to think about the exercise of a government function to embody that activity, the people of South Africa, the legal fraternity, cannot but read in that government exercise a scorecard, an assessment, a government function leading to the assessment of whether the Constitutional Court is doing well or is not doing well, whether one agrees with it or one disagrees with it. How can we not step back and say this is an attack on the independence of the judiciary? If that independence, as the Honourable Schaefer was reading before,
Your time is up, Honourable Member.
Means to have a measure of executive restraint.
I suggest to Honourable Member Ambrosini to read the document, but in any event, I don't think you've read it. In any event, many legal organizations in South Africa have supported this initiative. The Black Lawyers Association has been unequivocal in supporting this dialogue and the basic tenets that are enunciated in the document. The National Association of Democratic Lawyers, NADEL, the phoning program this morning with the Deputy Minister on SFM, majority of South Africa, they applaud this initiative. Kaya FM, I was there last night, the same story. So this notion that the majority of people do not support this is not borne by facts. So the majority of South Africans, we're going to be working with them in moving forward to this transformation agenda of all arms of the state.
What is the Minister of Police doing to prevent policemen and women who are being investigated for misconduct from receiving promotions while being under investigation? That's our question after the break. Stay with us.